Hi again. Welcome to another episode of Ask the Lawyer. I'm Rob Rosenthal with AskTheLawyers.com. Our plan today is to ask the lawyer about what happens if one party in a divorce decides to withhold child support. And luckily, we have attorney Kelli Hooper of KBH Law in the Atlanta, Georgia area here to answer our questions. Kelli, thank you for being here today. I appreciate it.
No problem. Thanks for having me.
All right, so the divorce is final. You've worked out custody, you've worked out alimony, child support. All the ugliness is over. Except that's not always the case. And sometimes one parent just refuses for whatever reason to pay the child support that is required. Does this happen? How often does this happen? How often do you see this kind of thing happen?
Oh, goodness. Well, hopefully in cases, when we finish out everything, we hope that doesn't happen. But, it does. I can't give you a percentage. I guess it's probably, I would hope somewhere less than 50% of the cases, especially if there's been attorneys involved. But it does happen.
And so then what happens? What is the parent who's supposed to be getting the support? What are their options?
Well, their option, honestly, is to go back to court and enforce the order. So in Georgia, that's called a contempt. And so you would file a petition for contempt with the court, inform the court that they issued an order on a certain date, and then the other party is not paying. Now, generally, before I take a case for contempt or before we file for contempt, I usually will try to figure out what exactly is going on. Oftentimes it could be just stubborn, someone being completely stubborn, right? And just not wanting to pay.
Out of spite.
Sometimes, right. Sometimes it may be where the parent doesn't understand where the payments are supposed to go. And so they've been sending payments to one address and, they've accumulated somewhere and the receiver parent has not received the funds. That's an easy solution, right? We just contact the other side, tell them we haven't received the monies. And then miraculously, you find out that the money's been sent to an address that maybe isn't any good, or they're supposed to be paying to, through a bank account and there's a number wrong. That happens infrequently, but you have to give people the benefit of the doubt and at least ask before you file a contempt. In other instances, there's a lag. So let's say, for instance, there is an order for payment of child support, and then the payor parent is paying through the Office of Child Support Services. Well, often there's a 2 or 3 month delay in getting the office to start to not only receive those funds, but to transmit them to the receiving parent. Sometimes that's the issue. And so what I typically will do is do some investigation first before I run off to the courthouse and file a contempt to try to enforce an order.
Now, if it's none of those reasons, if it's the payor says they just aren't financially able to make the payments, is that something that is that a legitimate claim?
Often no. So payor parents should understand that while they have an obligation to pay, that those payments are due and payable each month. And to the extent that they have not gone back into court and made any sort of representation that they're unable to make those payments and had a new order, that every month those payments are being logged as an unpaid payment. The penalties could vary anywhere from losing a driver's license to losing a professional license to losing a passport if their payments are being made through the Office of Child Support Services. On the civil side, what I call just enforcing through the Office of or through Superior Court, you could be looking at jail time. You could be looking at attorney's fees and cost. So it's really important for a payor parent, if they were to experience unemployment or some sort of drastic change in their ability to pay, to get in front of a judge as soon as possible to get those payments to stop and lowered to the correct amount.
What about bankruptcy? Does that change an obligation to pay child support?
It does not. You cannot discharge your child support obligations through bankruptcy, nor can you discharge an arrearage, so an amount that you owe because you weren't able to make payments through bankruptcy. There's a carve out for those. They're called post-divorce judgments or collections. There's a carve out for those in the bankruptcy code.
What if the payor moves out of state, or even worse, moves overseas? I assume that doesn't relieve their obligation, but I also assume it would make it a little harder to collect.
Well, it depends. If they move out of state, that's an easier proposition than if they move out of the country. So let's take them one step at a time. Okay. Let's say there's an order from Georgia and dad decides he's moving to Alabama. Well, so long as mom and child are in Georgia and the Georgia Office of Child Support Services is collecting, then they will go ahead and enforce and collect in Alabama. Let's say dad decides he's going to pick up and move to London. Well, Georgia can still enforce and collect on a child support obligation in another country.
Hmm.
The tricky part comes in as to whether or not there's an international code that dictates which countries will allow collections from the United States and which will not. And so it would require someone who knows what they're doing, hire an attorney to help figure out how to enforce collection on a foreign judgment, foreign, either domestically foreign, meaning a different state, or foreign, meaning foreign another country
Right.
altogether.
What are the options then for the, I guess, payee parent, the one who's supposed to be collecting, while this process is going on and they're not getting, it could create financial hardship where they're not getting that child support. Are there options, something they can do to help cover their bills in the meantime?
Well, not really.
Not
You just enforce the order. And so if there are no payments coming, then there's an arrearage that's accumulating. I've seen cases where payor parents have owed, 5-6 figures in unpaid child support. And if you think about the stories that you hear sometimes on the news with celebrities, you'll find someone that, has an extraordinary amount that they haven't paid. And that just happens. The receiving parent has to sort of make it work while they're waiting for those funds to come in. The bright side, I guess, to receiving non-payment is that the obligation does not end when the child turns 18. So you could potentially have a child who's, 30, and the payor parent is still making child support payments not because they owe it on an ongoing basis for the child, but because they just have this outstanding debt that can't be discharged by bankruptcy and still owed and collectible by the parent and by the minor child.
How important is it, Kelli, to get a family attorney involved in this sort of situation to help get some redress here?
Well, I generally suggest that most people consult with an attorney before they file a contempt, because the burden is on the pleading party. So the party who brings the case for contempt has the obligation to show the court that there was an existing order, that the order wasn't followed, and that they've been harmed by it, and then go through the steps for collection. Some people may be able to handle it pro se, but a sophisticated family law attorney is really your best bet in that circumstance.
And sometimes maybe the getting an attorney involved can make it or get things fixed before you get to contempt, like you said earlier.
Absolutely. Most attorneys that I know will do some investigation before they file the contempt, because what the wrong thing, really, in my opinion, is to file a contempt without knowing the circumstances behind it. I would never go into court and try to enforce an order without knowing for sure that the person is in willful violation of the court's order, because that's your standard. It's not that just that they're violating the court's order, but it has to be willful. And so in order to meet that burden, you need to show that the person had knowledge of the order and is willfully violating it. That's how you win a contempt.
At what point should the person who's supposed to be receiving the support contact an attorney? When they miss the first payment, or I'll give them a couple of payments? What point in the process should they get somebody like yourself involved?
Well, I would say at least 2 payments behind. I usually would give people a benefit of the doubt for the first one. But by the time there's a second payment, generally, you're looking at a number that at least has a comma in it. So it's becoming important for the receiver parent, and it's something that the payor parent should be aware of.
Kelli, thank you as usual for your time and helpful information. I do appreciate it.
No problem. Thanks for having me.
That's going to do it for this episode of Ask the Lawyer. My guest has been attorney Kelli Hooper of KBH Law in the Atlanta, Georgia area. If you want the best information about family law, or you're ready to choose a lawyer that lawyers choose, make sure to visit askthelawyer.com. Also, please subscribe to our YouTube channel by clicking on the button at the bottom of the screen. Thanks for watching. I'm Rob Rosenthal with askthelawyer.com.